an unlimited timeline for the Creative Commons.
Copyright. Noun. The exclusive legal right to reproduce, publish, sell, or distribute the matter and form of something such as a literary, musical, or artistic work.
In 1710, Parliament enacted England's first copyright law, the Statute of Anne, which gave authors exclusive rights to their works for a limited period, 21 years for works already in print and 14 years for works published thereafter. The express purpose of the statute was to encourage creativity and innovation by providing legal protection and financial incentives for authors and publishers.
Whereas printers, booksellers, and other persons have of late frequently taken the liberty of printing, reprinting, and publishing without the consent of the authors, to their very great detriment, and too often to the ruin of them and their families. For preventing therefore such practices for the future, and for the encouragement of learned men to compose and write useful books, the author shall have the sole liberty of printing and reprinting such book and books for the term of 14 years.
The importance of this law did not go unnoticed in the United States of America. One man in particular, Dr. Noah Webster, recognized its importance during the early formation of the government's Constitution. In 1782, 1 year before publishing A Grammatical Institute of the English Language, he was deeply concerned with safeguarding the value of his work. One of Webster's biographers described the following scene outside Independence Hall in 1782 with James Madison and Thomas Jefferson.
All approved Webster's scheme for a national system of instruction and agreed to support copyright protection, but, they pointed out, the Articles of Confederation gave Congress no power to enact, let alone enforce such a law. The Congress could only resolve to recommend that each of the states pass its own copyright legislation.
Consequently, not long after that conversation, Webster wrote his draft of what would become the first copyright law in the United States, Connecticut's an Act for the Encouragement of Literature and Genius.
Whereas it is perfectly agreeable to the principles of natural equity and justice that every author should be secured in receiving the profits that may arise from the sale of his works, and such security may encourage men of learning and genius to publish their writings, which may do honor to their country and service to mankind.
And so, in the following year, Connecticut became the first state to pass a copyright law. That same year, they were followed by 5 other states: Massachusetts, Maryland, New Jersey, New Hampshire, and Rhode Island. Pennsylvania and South Carolina passed their copyright laws in 1784. The following year, in 1785, North Carolina passed its own copyright law. And by 1786, when Georgia, New York, and Virginia passed copyright legislation, all 13 of the colonies had passed some version of a copyright law. As the framers of the Constitution began their work, South Carolina's Charles Pinckney and Virginia's James Madison both worked on versions of copyright law in 1787. Although mostly working independently, each included similar language in their proposals, often using the language of those produced in the 13 colonies.
To secure to literary authors their copyrights for a limited time. To encourage by proper premiums and provisions the advancement of useful knowledge and discoveries. To secure to authors exclusive rights for a certain time.
Madison defended the importance of passing some form of a copyright law in the Federalist Papers, a series of essays advocating for the ratification of the United States Constitution.
The utility of this power will scarcely be questioned. The copyright of authors has solemnly adjudged in Great Britain to be a right at common law. The right to useful inventions seems with equal reason to belong to the inventors. The public good fully coincides in both cases with the claims of individuals.
Finally, in 1790, Article 1, Section 8 of the Constitution established the federal government's authority over copyright.
Congress shall have the power to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries.
What's worth noting is that this is the only time that the word right appears in the original Constitution, and it is the only clause with a built-in justification. Later that year, George Washington signed the nation's first copyright law, an act for the encouragement of learning by securing the copies of maps, charts, and books to the authors and proprietors of such copies. He was undoubtedly happy to do so given his advocacy for innovation and learning, a position he made clear in his first State of the Union address.
There is nothing which can better deserve your patronage than the promotion of science and literature. Knowledge is in every country the surest basis of public happiness.
In the beginning, Copyright protection in the United States lasted for 14 years from the date of publication with an option to renew for another 14 years, meaning individual works could be copyrighted for a maximum of 28 years. But copyright protection was not automatic. Authors first had to submit their works to a clerk's office of the nearest district court before publication. Then, another copy of the work had to be delivered to the Secretary of State within 6 months of publication. Finally, a copyright notice had to be published in 4 weekly advertisements in a newspaper. In 1802, the copyright process became a little more complicated, requiring authors to include copyright notices on or in their published works. In 1831, copyright law underwent its first significant revision. And once again, Noah Webster played a major role in lobbying for the amendment.
I sincerely wish our legislature would come at once to the line of right and justice on this subject, and pass a new act, the preamble to which shall admit the principle that an author has by common law or natural justice the sole and permanent right to make profits by his own labors, and that his heirs and assigns shall enjoy the right, unclogged with conditions.
The 1831 revision gave widows and children of deceased authors the right to renew a copyright, and instead of 4 newspaper notices, only 1 notice was required for a renewal. But perhaps most importantly, the length of copyright protection was expanded to 28 years, plus an additional 14 years if renewed. In its first ruling on copyright, the Supreme Court determined in 1834 that authors have perpetual rights to their unpublished works, but rights are limited once the work is published. At the bequest of President Theodore Roosevelt, the first major revision to copyright law since the Copyright Act of 1831 occurred in 1909.
Our copyright laws urgently need revision. They are imperfect in definition, confused and inconsistent in expression. They omit provision for many articles which, under modern reproductive processes, are entitled to protection. They impose hardships upon the copyright proprietor which are not essential to the fair protection of the public. They are difficult for the courts to interpret and impossible for the Copyright Office to administer with satisfaction to the public.
One of the more important terms that was clarified in the Copyright Act of 1909 was work for hire, a doctrine that specified that when a work is created by an employee within the scope of their employment, the employer, not the employee, is considered the legal author and copyright holder of the work. The Copyright Act of 1909's most crucial effect was granting both individual works and works for hire an initial 28-year copyright term with the option to renew for another 28 years, increasing maximum protection to 56 years. In 1976, there was a major push to update copyright laws, primarily for 2 reasons. First, many felt that the effects of technological advancements on what could be copyrighted, how works could be copied, and what constituted infringement needed to be addressed. Second, many felt that the statutes needed to be amended to bring United States copyright law into accord with international standards, practices, and policies. One of the leading proponents of the changes was Barbara Ringer, the then Register of Copyrights.
Practically everything in the bill is the product of at least one compromise, and many provisions have evolved from a long series of compromises reflecting constantly changing technology, commercial and financial interests, political and social conditions, judicial and administrative developments.
One major clarification from the Copyright Act of 1976 was the definition of fair use. The concept of fair use originated in English common law, where courts recognized that certain uses of copyrighted works did not constitute infringement if they were reasonable and did not harm the market value of the original work. But the term itself was never codified until the Copyright Act of 1976, in which the fair use doctrine provided a clearer legal framework and formal recognition of fair use in the statute.
Purposes such as criticism, comment, news reporting, teaching including multiple copies for classroom use, scholarship, or research is not an infringement of copyright.
In determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include 1. The purpose and character of the use, including whether such use is of a commercial nature or is for nonprofit educational purposes. 2. The nature of the copyrighted work. 3. The amount and substantiality of the portion used in relation to the copyrighted work as a whole. And 4. The effect of the use upon the potential market for or value of the copyrighted work.
Probably to no one's surprise, the new Copyright Act once again lengthened the terms of copyright, but they were arguably more complicated than ever before, which is possibly why the United States Copyright Office published a general guide to the Copyright Act of 1976, seemingly in anticipation of arguments against lengthening the terms of copyright. Again,
Life of the author plus 50 years after his or her death is the term for works created after January 1, 1978. In the case of joint works by two or more authors who did not work for hire, the 50-year period is measured from the date of the death of the last surviving author. In the case of anonymous or pseudonymous works, the term lasts for 75 years from the year of first publication or 100 years from the year of its creation, whichever expires first. If the identifier of the author is revealed in the records of the Copyright Office, the term will be based on the life of the identified author plus 50 years. With works made for hire, the term is 75 years from first publication or 100 years from creation, whichever term is shorter.
Again, seemingly in anticipation of backlash, the guide also included a list of justifications.
56 years is not long enough to ensure an author and his or her dependents the fair economic benefits of the work. Also, life expectancy has increased substantially. Tremendous growth in the communication media has substantially lengthened the commercial life of many works. A short term discriminates against serious works, whose value may not be recognized until many years after its creation. There is no particular benefit to the public of a short term. The price of public domain works is usually no less than that of copyright works. In some cases, the lack of copyright protection restrains dissemination, since publishers cannot risk investing unless they are assured of exclusive rights. The year of death is a simpler and clearer method of computing the term. All of a particular author's works will fall into the domain at the same time. The renewal device, one of the worst features of the 1909 Act, will eventually be eliminated. It places the United States in conformity with most of the international copyright community.
In 1998, Congress passed the Copyright Term Extension Act, also known as the Sonny Bono Copyright Extension Act, also known as the Mickey Mouse Protection Act. Sonny Bono was not one of the primary authors of the bill, but he was one of its more prominent advocates. Tragically, he lost his life in a skiing accident prior to the bill reaching a vote. His name was subsequently added to the bill in his honor, and his wife Mary Bono succeeded him in Congress, where she continued advocating for the bill.
Sonny wanted the term of copyright protection to last forever. I am informed by staff that such a change would violate the Constitution. As you know, there is a proposal for term to last forever less one day. Perhaps the committee may look at that next Congress.
Of course, Bono's staff was exactly right. As stated in the Constitution, Congress holds the power to foster the progress of science and useful arts by ensuring that authors have exclusive rights to their writings and discoveries for limited time. Not forever, limited. And while it is unlikely that forever less one day would ever be seriously considered, Bono's arguments reflected the increasing friction between proponents of shorter copyright durations and those who favored near-permanent copyright protection. Fairly or not, the Sonny Bono Act was frequently referred to as the Mickey Mouse Protection Act in large part because Walt Disney's first version of Mickey Mouse, Steamboat Willie, was within years of entering the public domain. And though Steamboat Willie never officially had his day in court, the tension between these two interpretations would spill over into the real world. In 2003, Eric Eldred, an internet publisher who relied heavily on public domain works, challenged the CTEA, arguing that the extension was unconstitutional. The legal dispute escalated to the Supreme Court, focusing on whether the Sonny Bono Act violated the copyright clause of the Constitution. Stanford law professor Larance Lessig played a pivotal role in Eldred versus Ashcroft as the lead attorney representing Eldred and other plaintiffs. He argued before the Supreme Court that the Copyright Term Extension Act was unconstitutional because it effectively created copyright terms that went beyond the pale of the limits established by the Constitution. He also incorporated First Amendment rights into his argument by asserting that the act limited free speech by restricting access to creative works that would have entered the public domain. Lessig regarded Eldred versus Ashcroft not just as a crucial arena of intellectual dispute, but as a battle over cultural values.
Copyright is controlled more extensively than ever because the interests that would control this are as powerful as they have ever been in the history of free culture. Now this culture war, is the insane unintended consequence of the law that has been bloated by 200 years of lobbyists. Ripping, mixing, and burning the culture around you is an expression of a certain kind of freedom, but there is now a war being raged against rip, mix, burn culture. Lobbyists have convinced the world that there's a constant value out here called copyright, which is threatened by this new form of expression.
During the Supreme Court hearing, the question was posed by multiple judges about why copyright terms should not be expanded if they had never been challenged in court before now.
The fact that previous copyright laws were never challenged Perhaps most people, and perhaps everybody, felt there was no basis for challenging them.
It's absolutely true that this case is here because of a fundamentally important change circumstance that makes the framers' limitations on the copyright clause much more significant.
Because for most of this period, the only people who were regulated by copyright law under the Copyright Act would have been commercial publishers primarily, and now for the first time the scope of this exclusive right has expanded because of the changed technology of the internet to reach an extraordinarily broad range of creativity that never would have been imagined before.
Of course, one of the most challenging issues before the court was determining what the framers of the Constitution intended by the phrase limited times.
Well, I could agree with you in terms of policy that this flies directly in the face of what the framers had in mind, absolutely. But does it violate the Constitution?
Well, if it flies in the face of what the framers had in mind, then the question is there a way of interpreting their words that gives effect to what they had in mind? And the answer is yes.
Solicitor General Theodore Olson argued that any duration less than forever was technically limited, asserting that Congress had the obligation to meet the public's evolving needs.
It isn't inconsistent for the Congress to exercise its responsibility under this broad grant of power to determine that there could be many ways in which the holder of an existing right may benefit the public by continuing to have that right for an additional period of time, the same reason that Congress had when it created the right in the first place.
Justice Ruth Bader Ginsburg was not convinced.
But there has to be a limit. Perpetual copyright is not permitted. Who is the judge of when it becomes unlimited? What standard would this court apply to determine whether something short of perpetual is still unlimited?
Though ultimately unsuccessful, Lessing closed his arguments by reminding the court that words and intentions have meaning.
We have 125 years of history of this court making sure that the limits, both express and implied, in the copyright clause, have some meaning. Those limits make no sense under the reasoning the government has offered. The government's reasoning would make all of those opinions irrelevant and wrong.
Despite Lessing's argument, even Justice Ruth Bader Ginsburg, who agreed that perpetual copyright is not permitted, had to concede that the framers of the Constitution did not specify the meaning of the word limited clearly enough to impose a restriction on duration.
This court cannot agree with petitioners that extending the duration of existing copyrights is categorically beyond Congress's Copyright Clause authority. At the time of the framing, limited meant what it means today: confined within certain bounds, restrained, or circumscribed, a time span appropriately limited.
However, in the minority opinion, Justice Breyer emphasized that extending copyright so far beyond the author's life primarily served the interests of others, not the author.
The economic effect of this 20-year extension is to make the copyright term not limited, but virtually perpetual. Its primary legal effect is to grant the extended term not to authors, but to their heirs, estates, or corporate successors, and, most importantly, its practical effect is not to promote, but to inhibit, the progress of science, by which word the framers meant learning or knowledge.
Despite losing the case, Lessig and his supporters viewed it as a chance to redefine, quite literally, the traditional terminologies and practices associated with copyright. They understood the necessity for a more flexible and contemporary approach to copyright that could better accommodate the demands of the digital age, surpassing the limitations and ambiguities of conventional copyright law. In 2001, 2 years before the Supreme Court case was even decided, Elward and Lessing helped create what would become known as the Creative Commons licenses, a more flexible and modern approach to copyright that could adapt to the digital age's demands better than the limited and ambiguous language of traditional copyright law. Since, by law, all created works are automatically copyrighted, that means that users are automatically restricted by all laws related to copyright. However, if an author wants to give others more rights, he or she can use the appropriate Creative Commons license to make those permissions clear and legal. Creative Commons icons have become ubiquitous symbols for sharing, openness, and human collaboration.
Creative Commons exists to make permissions explicit and straightforward. Creative Commons licenses use icons and simple language so that creators can make their intentions clear and users can be certain that their use of a work is legal. These different licenses help people understand if and how they can use, share, or build on a work. This icon means that only non-commercial uses are permitted, so no one can profit from using your picture. This icon means that no one can make changes to the original work, such as photoshopping a dog into your cat picture. This icon means that someone can change your work, but their version must be shared under the same license as yours. All Creative Commons licenses give credit to the original creator, preserving your reputation as a creative genius while the world engages with your work.
20 years ago, we set out to build a commons of open creative content free of most copyright restrictions. With the CC licenses and tools, we created a simple way for creators to opt in to a more permissive model of sharing. Over the past 2 decades, these legal tools have been applied to nearly 2 billion works, and they have become one part of a grand global open movement comprising open education, open science, open data, open culture, open access, and more. Our mission: Creative Commons empowers individuals and communities around the world by equipping them with technical, legal, and policy solutions to enable sharing of knowledge and culture in the public interest. Today, more than 2.5 billion works with Creative Commons licenses can be found on millions of websites in countless desktop folders and attributed in an unimaginable number of new works produced each day. And as the number of these licenses grow, the landscape of intellectual property and creative expression is evolving, pushing forward a new era of open source knowledge and innovation.